Statcon Radio! Kung sa Statcon Radio mo naminaw, sa Statcon Radio na mo pagpuyo! Good evening everyone! Welcome sa Statcon Radio, istasyon nga kasaligan kung balaod ang pagkaisgutan. Welcome usab sa atong mga listener o sa atong mga viewers sa Facebook Live sa naglalayong lugar sa tibuok Pilipinas o sa tibuok kalibutan. Ano sa kita karon sa atong segment kung diin ang mga mulo sa atong mga listener bahin sa balaod, tagaan at pagkasulbaran. Espesyal kini nga gabi karon kaya doon na kita yung mga bisita. Bisita gikan sa Statcon Radio Angkor sa naglalayong lugar sa Mindanao. Ani karon atong kauban si Statcon Ubihiro gikan sa Bohol, si Statcon Bakas gikan sa Siquijor, o si Statcon Matalinis gikan sa Camiguin. O aduna sab kita mga bisita nga mga lawyer kung diin maghatag og kasulbaran sa mga mulo sa atong mga listener nga ilang gipadala bahin sa balaod. Uban kanato karon si Attorney Uba, o si Attorney Batalunis, o si Attorney Neri, kung diin gigahinan kini nilang oras para ang atong mga listener uban sa ilang mga mulo balahin sa balaod matagaan og kasulbaran. Dili na nato lugayon pa, ato nang ihatag ang atong linya sa atong anchorman gikan sa Statcon Radio Bohol, ang atong kastat Ubihiro, para sa pagpasundayag sa reklamo sa ilang mga listener bahin sa balaod. O kini gilangkuban social kini, gilangkuban sa presumptions against absurdity. Kastat Ubihiro, pasok!
Hello, good morning mga kastats. Ito po ang inyong anchorman, Kastats Ubihiro. Ang topic po natin ngayon is about the presumptions against absurdity. Ito po is mayroong mga cases. So, ang cases na ito ay tungkol sa Commissioner on Internal Revenue versus ISO. So, Standards Training Corporation and the Court of Tax Appeals. So, the fact of this case is about the overpaid of ISO. It's in income tax by the 221,032 pesos. It was accordingly granted a tax credit in this amount by the Commissioner on August 5, 1964. However, ISO payments of its income tax for 1960 was found to be short by 367,929 pesos. So, on July 10, 1964, the Commissioner wrote to ISO demanding payment of the deficiency tax together with interest thereon for the period from April 18, 1961 to April 18, 1964. So, it claimed that it should not have been required to pay interest on the total amount of the deficiency tax of 367,924 pesos, but only on the amount of 146,961 pesos. And ISO earlier overpaid 64,999 pesos. In this case, the Internal Revenue Commissioner denied the claim of refund. So, ISO referred to the court and ordered payment to ISO of his refund, claimed the amount of 39,787 pesos and 94 cents. Hence, this appeal by the Commissioner. So, ito ay ating ipapalo up po kay Attorney Uba. Attorney Uba, ano po yung masasabi niyo?
Salamat ISO sa inyong ipadang tumulo about sa inyong problema sa tax. Daghang salamat po sa atong maptiko nga din si karon si Sir Ubihiro, sir. Daghang salamat po sa mga listeners sa Statcon Radio nga madugang kita mula batali sa kagulo. O makita kita Facebook Live, di mo kalimutan sa Statcon Radio Facebook page. Regarding sa inyong problema iso about sa tax, ang Court of Tax Appeals na mismo nag-ingon na as early as 1960, the government already had in its hands the sum of 221,000 representing excess payment having been paid and received by mistake, as BIR subsequently acknowledged that some unquestionably belong to ISO, and the government had obligation to return it to ISO. Dapat iuli sa BIR ang 221,000 na sobrang bayad sa tax sa ISO tungkol kay di acknowledge the erroneous payment came some 4 years afterwards in no wise negates or distract from its actuality. The obligation to return money mistakenly paid arises from the moment that payment is made. Dapat iuli to diretso sa BIR immediately ang excess payment of tax, and not from the time that the payee admits the obligation to reimburse. The obligation to return money mistakenly paid arises from the moment that payment is made, and not from the time that the payee admits the obligation to reimburse. The obligation of the payee to reimburse an amount paid to him results from the mistake, not from the payee confession of the mistake of recognition of the obligation to reimburse. So mao kadto no, nanginaot ko nga makahatag ko gamay nga kasulbaran sa inyong problema, o kung unsa pa man yung problema diya sa kinabuhi, ayaw lang kwarta o gugma kay parehas na walay uyab o walay sabi.
Salamat kayo Statcon Radio Bohol o sa kay Attorney Uba sa paghatag og kasulbaran sa problema sa balaod sa atong listener gikan sa Bohol. Cool ba usab no? Hapit ko mag-nosebleed. So sa atong mga listener diha nga naminaw karon sa Statcon Radio, pagtapad ka mo og dictionary. Anyway, moadto na sab kita, moambak kita sa Statcon Radio City Hall. Na ang atong anchorman, ang gwapo nga ka-stat Bakas. Pasok!
Hi, good evening everyone. I am your ka-stat Lucio Bakas Jr. Tonight we have a letter from Cesario Ochoa. Cesario Ochoa was a community environment and natural resources officer assigned in Kidapawan, Cotabato City. He was involved in some illegal cutting of mahogany trees in the said area, and a complaint was filed against him by the Sandigang Bayan. Cesario Ochoa went to the office of the Ombudsman in Davao City, and he wrote a letter which wrote by his counsel Attorney Pulmonis to get the furnished copy of the complaint, and since his messenger was not available at that time. So upon reaching the office, Cesario Ochoa, instead of using his name on the logbook sheet, he wrote Oscar Perez and then hand over the letter to one of the officer, Luida Hulugan, in that office. And later on, they found out that the person introduced named Oscar Perez was actually the petitioner, and it was reported to the Ombudsman, and the Ombudsman ordered that the petitioner accordingly be charged with the violation of Section 1 of Commonwealth Act number 142. The petitioner then filed demurrer to evidence, alleging that the failure of the prosecution to prove that his supposed alias was different from his registered name. But still, the Regional Trial Court found him guilty in the violation of Section 1 of the Commonwealth Act 142. So the petitioner filed appeal in the Court of Appeals. Now he contended that he never used any alias name. He only used such alias on one occasion, and with full consent of Mr. Oscar Perez. So now the issue is whether or not Cesario Ochoa violated the Section 1 of Commonwealth Act number 142 as amended by Republic Act 6085, or otherwise known as an act to regulate the use of aliases. So this case I will forward to Attorney Batallones and to help us giving some legal advices. So Attorney, thank you.
From our sender, Cesario Ochoa, ug sa atong anchor kastat Attorney Bakas, I, Mary Jane A. Batallones, So, Cesario, you may be covered by other provision of law such does that constitute an offense within the concept of Commonwealth Act number 142 as amended. So, Section 2 of Republic Act number 6085. The confusion of fraud in business transaction which the anti-alias law as its related statute seek to prevent are not present here as the circumstances. There exists a valid presumption that undesirable consequences were never intended by a legislative measure, and that a construction of which the statute is fairly susceptible is favored, which all avoid all objectionable, mischievous, indefensible, wrongful, evil, and injurious consequences. Sa imong judgment, Cesario are reversed and set aside and is acquitted, free from a criminal charge by verdict of not guilty. Thank you, Cesario also.
Daghang salamat, Statcon Radio Sikihor. Uban sa ilang angkurman ka Stat Bakas, angkurman na, aktor ni pa. Daghang salamat usab kay Attorney Batalyones diin naghatag og kasulbaran sa problema ni Cesario Ursua bahin sa balaod. O ginaot ta sa atong listener nga si Cesario Ursua na tagaan kini kasulbaran. Kung galing man naglibog ikaw, halabasaha na sa PDF, Statcon PDF, page 168. Okay, mo ambak na sab kita dito sa Statcon Radio Station Kamingin. Uban sa ilang angkurman ang atong Kastat Matalinis. Kastat Matalinis, pasok!
Good evening, Kastat. I am Attorney Maria Darlene Panganiban Matalinis, and I am happy to serve. Thank you for having me in this program tonight. Before anything else, let me talk briefly on the presumption against violation of international law. What is this presumption, Kastat? This presumption is in conformity with the Declaration of Principles and State Policies in our Constitution. It states that the Philippines as a democratic and republican state adopts the generally accepted principles of international law as part of the land and adheres to the policy of peace, equality, justice, freedom, cooperation, and amity with all nations. And one of our letter senders tonight is Lievelio C. Agustin, a petitioner over LTO Commissioner Romeo F. Edo, on the validity of the Letter of Instruction number 229 of President Ferdinand E. Marcos issued on December 2, 1974, requiring motor vehicles of early warning devices or EWD, and this is in conformity with the 1968 Vienna Convention on Road Signs and Signals. Facts of this case: Lievelio C. Agustin owned a Volkswagen Beetle car model 13035. When it came out from the assembly lines, it is already equipped with blinking lights, fore and aft, which could very well serve as an early warning device in case of the emergencies mentioned in the LOI number 229, as well as the implementing rules and regulations in AO number 1 issued by LTO. He contended that LOI 229, besides being violative of the new constitution, it is also harsh, cruel, and unconscionable to the motoring public, and that it will make manufacturers and dealers instant millionaires at the expense of car owners who are compelled to buy a set of the so-called early warning device at the rate of 56 to 79 pesos. He therefore prayed for a judgment declaring letters of instruction and memorandum circulars void and unconstitutional, and for the restraining order in the meanwhile. So the facts here are undisputed. Statistics shows that one of the major causes of fatal accidents in the land transportation is the presence of disabled, stalled, or parked vehicles without any appropriate warning devices. The hazards posed by such obstruction to traffic have been recognized by the international bodies concerned with traffic safety, like the 1968 Vienna Convention and the United Nations organizations. The said Vienna Convention was ratified by Philippine government under PD number 207, which recommended the enactment of local legislations to the installation of road safety and signs and devices. Issue here is whether or not letter of instruction number 229 as amended violates the provisions of the new Constitution on due process, equal protection, and delegation of police power. So for more on this case of Agustin and Edo, here is Attorney Neri of the Neri and Associates Law Office for her advice and wisdom. Attorney Neri, take it away.
So good evening, Sir Agustin, and good evening, Mama Delines. In your case, Sir Agustin, you are questioning the validity of the letter of instruction, which requires an early warning device to be carried by users of motor vehicles. So the answer is yes. The LOI was a valid exercise of police power. As identified, police power is a state authority to enact legislation that may interfere with personal liberty or property in order to promote the general welfare. And in this case, a particular exercise of police power was clearly intended to promote public safety. And in addition, the UN and the Vienna Convention, both ratified by the Philippine government, recommended the enactment of local legislation for the installation of road safety signs and devices. The Constitution provides that the Philippines adopts the generally accepted principles of international law as part of the law of the land. Thus, it is not for this country to abandon a commitment to which it will pledge its right. So that's it. I hope I've answered your question, Sir Agustin. Thank you for the time, and thank you also to Mama Delines. Good evening.
Kita nyo yan mga kastat, hindi basta-basta ang atong angkurman gikan sa Kamigin. Angkurman attorney pa. So mga kastat, ang atong Statcon Radio dili basta-basta. Salamat kayo Statcon Radio Kamigin o sa atong resident lawyer Attorney Neri, daghan kayong salamat, no? Napaka mahinahon ng kanyang boses, no? Siguro para dili makadisturbo sa silingan. Mga kastat, hinaot paunta ang mga kaso nga inyong ipadala sa atong stasyon Statcon Radio na taga Kasulbaran. Usbon ko, kung galing kamo may kalibog, ala, o ka ba ang atong Statcon PDF, aduna kita makita ka na sa page 167 hangtod sa 169. Kini ang inyong angkurman, J. Lord Melgaso. Maayong gabi. O usbon ko, kung sa Statcon Radio mo naminaw, Statcon Radio na mo puyo. Daghang salamat o maayong gabi. Statcon Radio! Kung sa Statcon Radio mo naminaw, sa Statcon Radio na mo pagpuyo!